Thank you, everybody, for signing on to our webinar, U.S. Immigration Strategies for Biotechnology Companies. I am Miki Matrician, partner at WR Immigration, and I'm really excited to moderate this panel featuring my esteemed colleagues, partner Melissa Harms and Senior Associate Julie Galvin. So a little bit of housekeeping first. I have to let you know that anything we say during this webinar does not constitute any legal advice. And if you have a question that's specific to your company or your employee situation, then please contact one of our attorneys. We will accept questions in the Q&A box, and we will try to answer questions that we can throughout the Q&A feature. But for questions that are better addressed in a discussion, we will reserve those to the end. We will have time for questions at the very end. So please feel free to throw questions into the Q&A box. Okay. So a little bit about our firm. At WR Immigration, we specialize in employment-based matters. We have 8 offices across the U.S., plus 1 in Shanghai. And we pride ourselves in providing high-touch service, which is made possible by our proprietary technology, Rapid. Rapid is built on Salesforce and is customized to what our clients need. And the AI component makes Rapid all the more powerful. If you aren't already using Rapid, please feel free to reach out to us and we'll be happy to schedule a demo. I'm sure that you'll find it's a game changer for you. So as I mentioned, the experts we have on our panel today are Melissa Harms out of our San Francisco office and Senior Associate Julie Galvin, who is based in Boston with me. And we all represent a number of biotech companies of all sizes, from startups to publicly traded companies. And we're going to be talking to you today about immigration strategies specifically for your industry. So, we'll talk first about maximizing success on H1B visas. Then we're going to talk about the other options for people who were not selected in the lottery and how to avoid pitfalls in specific biotech jobs. Also, given how tight the labor market is, I know that talent acquisition and retention strategy are top of mind for a lot of people. So we'll reserve time at the end to talk about how to use benchmarking and policy setting to keep your talent. We really want you to come away with key nuggets that you can start implementing right away. So with that said, I'm going to turn to our first slide on H1Bs, which is by far the most common visa type. So I'll turn to you, Melissa. Can you tell us about the key components of an H1B for an approvable case?
Thanks, Miki. Yes, H1B is probably the most common visa we use. I know a lot of you have familiarity with H1B, but just to recap, to provide the context for our later discussion, the position must be a specialty occupation, which the USCIS defines as one that requires at least a bachelor's degree in a specific field. And that's very important. It has to have a degree in a specific field. And then the employee must have the degree in that field or the equivalent. And then lastly, we look at the employer needs to pay the wage, which is the prevailing wage for that occupation for that area. So those are the 3 components that we're all balancing together. These are the building blocks for H1B, but these also apply to H1B1, which is used for Singaporeans and Chileans, and for E3, which is used for Australians. Slightly different process, but the requirements are still the same for all 3 classifications.
Perfect. We want to delve a little bit more deeply into the specialty occupation requirement. And so, Melissa, can you talk to us about some challenges that biotech companies face?
Yeah, so looking at the job being a specialty occupation and matching the employee's degree, we use a government job classification system, which, like many things with the government, is a little antiquated and outdated and doesn't keep up, especially with some of the rapidly changing occupations. So in the biotech field, we're always looking for example, something to do with GXP compliance or a product manager of a certain drug. How do we classify those? We have the broad classifications of biochemists, biochemical engineer, chemists, some of our scientific ones, and we have some very broad business ones, but we don't have classifications that really match a lot of the sophisticated biotech positions that we need to sponsor for H1B. Even apart from that, we have a government occupational handbook that tells us the type of education that's normally required for a certain position. And that's what USCIS uses to decide if a bachelor's degree in a specific field is required. And that occupational handbook sometimes doesn't understand the complexity of a biotech position. One thing that we see, like a biological technician, for example, we use for a lot of our entry-level positions. They still require a bachelor's degree, but the handbook says that they don't. So what we are challenged as immigration attorneys is to really explain the duties with a lot of detail and explain the complexity of the position and why the degree is required for that role.
Right. So it's always this balancing act of looking at what is the best fit for the role and then looking at the employee's credentials, because sometimes it doesn't fit neatly. What about, for positions where it's kind of a combination, like a business and a science role combined, and maybe, you could conceivably fit into 2 or maybe 3 occupations? How do you deal with that?
And those are particularly challenging. I mean, there is a degree program here in the Bay Area that's actually a business of science degree. So we do see a lot of people that come out with that specific degree, and the biotech companies really want that degree, but it doesn't fit within the classification. We traditionally try to build upon the science because we have to choose between one. So if the individual has the requisite science background, we will classify it as a science position, because USCIS more commonly recognizes that the science positions require degrees. We'll use things like natural sciences manager, some of the more general fields like that. But if we use the business degree, we can do that. We just have to be very careful and very detailed about describing the business-related principles.
Thanks, Melissa. And then naturally, based on what job category we end up using, that's going to impact the prevailing wage. I mean, sometimes, you see situations where it's a senior level, maybe it's kind of a manager role, maybe it's not totally a manager role. What are some strategies that you employ around this?
Yes, this gets very challenging. So this is how immigration attorneys earn our chops. We have to look at the degree, the job, the classification, and then the wage as well. And will the wage be a fit? And we do see some challenges, particularly with our individual contributors in the scientific fields, such as you might have a biochemist who's risen in the ranks as a biochemist to be a very senior biochemist, and has some managerial duties. But do those duties rise to the level of a natural science manager? And sometimes we have to look at the salary to determine if that's going to be a fit. We generally want to stay, of course, true to what the position duties are. So we'll look to see if the managerial duties are incidental to the job description, or if they're a key component and make up more than 50% of the duties. So we're always looking at the prevailing wage, and then we work with our global mobility and HR partners, because it does seem complex, and sometimes we'll be straddling 2 different classifications, and so we'll go back to HR and say, what would the manager say is a better fit? And here would be the wages that we would need to look at for those different positions. And then lastly, with the age of intranet postings, I would say most of my clients now post their LCAs on the intranet, and the wage is posted electronically, and then the employees get a copy of this actual LCA. The employees might question us about why was I called a biological technician? My position is a research associate. So we have to educate the employees about this process, that it doesn't always match the internal classification for the role. So we partner closely with our clients to have a very open dialogue with the employee and the employer present, because of course there are sensitivities around the wage, and explaining that you're level 2 and not level 4 with the employee. So it is all a very delicate balancing act, for sure.
Totally agree. And, the government's prevailing wages can seem ridiculously high sometimes. So after looking at all of the strategies that you talked about, sometimes we just can't find a wage that's realistic. Do you have any suggestions?
Yes, and we work with a number of our clients to use an alternative wage survey, such as Radford has a great natural science database that we can use to support different wages. And so we'll use that internally, look at the Radford classification. if we can't use the government. We do tend to go with the government classification first because it's simpler, but we do use Radford and other alternative wage surveys when we just can't find a wage that fits.
Great. So with the H1B, there are regulatory issues that can come up for biotech positions in particular. I mean, the government considers it export of information when companies have foreign nationals touching certain types of technology. Can you talk a little bit, Melissa, about this component and what questions might come up for biotech positions?
Yeah, unfortunately, immigration attorneys were unwillingly brought into this discussion when USCIS placed a question on the I-129 form asking if the employee was subject to a license or needed an export control license. So all of a sudden, we are now asking our clients to give us that information, and it's an entirely separate field of law. So we work closely with our clients to have them engage an export control attorney to look to see if they need a license, and we do all that before sponsorship commences. But it is a question. It's outside immigration, but it's implicated by that form. And because our partners or our clients are signing these forms under penalty of perjury, we want to make sure that they've examined the need for a license and have complied accordingly. And oh, sorry, Miki.
Oh no, please go ahead.
This goes into a lot of regulatory issues we see. When they not only is it implicated at the I-129 when we file the H, but when people travel abroad and they go to the consulates, we are seeing administrative processing at the consulates, where particularly in China is one of the countries we see the most. If they are working with sensitive technology, which is defined as biological technicians or any sort of biomedical sciences, then they can be subject to a long delay when they get a visa. The most important thing that we do with our clients is make sure that they prepare for that before the individual leaves. And we have a policy in place for what happens if that individual is stuck outside the United States for months at a time. Can they work remotely? The manager has to give buy-in. And we do have separate policies based on whether the travel to get the visa was for personal nature or for business, a business reason. We also look at discrimination issues because we want to make sure that some countries, like I mentioned, China, some nationalities are subject to more heavy scrutiny. So we want to make sure that we're acting accordingly. And for example, we talked about the export control license, and it's actually a violation to not make your hiring decision based on whether or not somebody needs a license. So we make sure we educate our employers accordingly.
Great. Thanks, Melissa. So now it's September, and a lot of our clients have already gotten their H1 caps approved for October 1st start date. Some people have not been fortunate enough to be selected. Melissa, can you talk about some options that employers should not forget to think about in terms of cap-exempt employers and other options?
Yeah, unfortunately, the situation is getting worse and worse every year. We'll see what happens next year. In 2021, in our cap filings, I think they received about 308,000. This past year, it was 483,000 applications for that 85,000 number. So we're seeing more and more employers looking for other options. One thing that's come up increasingly is looking at, for example, when there are people based abroad who have been in the U.S. maybe in the distant past and they have not used all their 6 years of H1B status, we're able to recapture that. I just had a situation where somebody had been out for 20 years and we were able to use the remainder of the 6 years to get him into the United States to start a position. So we never forget to look at their immigration history when we're evaluating. I would say one of the things that comes up a lot with our biotech companies is the cap-exempt entities, which include a nonprofit or a government research institution or an institution of higher education. So if the individual is going to work part-time at one of those cap-exempt entities, they can also work for a cap subject like a biotech company together. So they can have part-time with both entities and not have to go into the cap with that cap subject. The drawback on that is if they stop working for the university, then they do have to go into the lottery once that capped exempt employment ends. We've also been very creative with this exception. There is a very little known exception if you are employed at a cap exempt entity. but paid by a private employer or paid by a cap subject employer, you can go into the cap. The major limitation with that is that your work really has to benefit the cap exempt entity. So a situation we've had recently was an employee was stationed at a lab, at a research lab, and they were doing work at the research lab that was cap exempt, and they were hired by a private company that was licensing that work. So the private company paid them, is licensing the work, but the work still benefits the overall lab's objectives. So we were able to get that individual cap exempt H1B.
Great, thanks, Melissa. So if someone didn't get a cap H1 number and the cap exempt option is not available, we want to talk next about alternative non-immigrant visa categories that might be an option for your employees. So, Julie, can you talk to us about people in F1 status? What options might be available there?
Sure. Thanks, Miki and Melissa. That was a great summary of the H1B. So what we see a lot of, and what I think employers see a lot of even before you're dealing with the H1B, are recent graduates that are looking to work in the US. And what I think employers are most familiar with is the OPT, the optional practical training, where recent graduates get an employment authorization document. It's a little plastic card that looks like a driver's license, and it allows them to work in the US for a year postgraduate, as long as this work is related to their field of study. It just has to be approved by the school. Beyond that, if somebody has a STEM extension or STEM degree, they can get a 2-year extension of that optional practical training. So they can potentially work in the US for up to 3 years before moving on to an H1B. The STEM OPT is a little bit different than the OPT. It is really considered more for training purposes. They must work with the employer to put together a training plan that the school will have to sign off on and approve. And the employer has to be an E-Verify company. So it's a little bit more restrictive than your normal optional practical training. But another option that I don't think a lot of people are as familiar with is curricular practical training. And this is really part of the student's schooling. So they're still considered enrolled in a course of studies. Thinking of in the Boston area, we have Northeastern University, which is well known for its cooperatives. So that is the type of program, a practicum, an internship, where the position is directly related to the schooling. So that's another case where the school would have to approve the employment, and then they can continue to work for a certain period of time. They don't even get an EAD, but they do get work authorization on their I-20 form. And sometimes that can be a good option, even for people that don't get the H1B lottery. If they've exhausted their STEM, sometimes we see them going back and applying for extending a program, applying for a new program that allows for curricular practical training, and they can continue to work on that.
Thanks so much, Julie. That's a really good summary. I think it's important to note that, not being selected in the H1 lottery and then going back to school to enroll and getting the CPT, there are lots of issues to kind of know about in advance. So consult your immigration attorney.
Sure. Yes, absolutely. So it is an option, and we do see that happen a lot, but it is a couple things to be aware of. One, the student really has to commit to being enrolled in a full course of studies. So they have to pay the tuition, they have to go in the program. The other thing that's important to note is USCIS, while this is permissible, this is heavily scrutinized, because sometimes USCIS wants to know that they are permitted to have this amount of practical training, that it is an integral part of the academic program, and that they are fulfilling all of the requirements for the program. So if an employee goes this route, it's important that they're very heavily documented. When this comes up in the context of if they then do become selected for an H1B, they may need to show that they did in fact meet all of their program requirements. And USCIS wants to see more than I-20s. In this case, we've gotten requests for very extensive documentation, tuition bills, school IDs, syllabi. If sometimes these schools are located in a different state, and maybe some of the courses are online while they're working in their home state. So proof of travel for when they've had to go based in person to the campus, et cetera. So it is permissible, but it's also not without some risk.
Right. So next we'll talk about TN visas. It's a category for nationals of Canada and Mexico. So, Julie, do employers have to worry about wages for TN visas?
No, the TN classification, if you have employees that are Canadian or Mexican, and it's important to note they have to be citizens, not just residents of those countries, this is a great option. There's no prevailing wage issue or requirement, as Melissa talked about with the H1B. For biotech companies, it can be a really great option because it's limited to certain list of occupations. So TN used to be under the NAFTA treaty. Now it's called the U.S.-Mexico-Canada Agreement. But the list of occupations remain the same. So as long as the occupation is on the list, it can be a great option. There are a lot of biotech-related positions on the list, including a biochemist, chemist, biologist. We can use a technical writer if it's a more broad regulatory affairs position. But it can be limited in that if the position is not on that list, then it's not an option, unfortunately. But another positive is it's very quick. So if the person, you can travel directly to the port of entry and apply as you're trying to enter the US and get a quick turnaround, as opposed to having to go through USCIS and filing petitions.
Right. What about for someone who has been promoted to a manager or director role? Do you have any concerns or things you think about when doing a TN for those?
Yes, this is when it can get tricky. So unfortunately, while all of the TN positions are really for professionals or those that support professional occupations, they are limited if you are a manager or a high-level administrator, for example. So general business professions or management level can be more difficult for TN. However, if it's a natural science manager, as Melissa talked about earlier on the H1B, if we can show that the TN applicant is really still using the expertise, so perhaps there's somebody that is reviewing and in charge of a clinical program, studies program, and they're supervising the scientists in that area, and they're really relying on their expertise, then that most likely would be approvable as a TN. So we really want to show the connection between their subject matter expertise and their degree that with the position that they're doing. However, if it's somebody that's really more concerned with the administrative aspects of a role, more budgeting, et cetera, then that may not qualify.
All right, so let's turn to O1 visas. I know the O1 has generally a high bar, but we do see quite a few O1s at biotech. And it's not really only for people who are in research. Can you talk about that?
Yeah, that's correct. We do a lot of O1 for biotechs, and we've had very good success rates. It is a high bar where you have to show that you meet at least 3 of the different criteria, which are generally list of publications, that you've made original contributions to the field, that you've won major awards, that you're a membership of a group that requires distinguished achievements from its members, that you've held a critical role. So there's several different criteria that we can use to qualify. But we have to, most often people think of it as scientists, researchers. Those are going to be the most straightforward. They're going to, just by virtue of their position, probably have a lot of publications, have done peer review work. But we've been seeing, and especially lately, I tend to be doing a lot of these cases for less traditional type scientific positions and doing them for more the combination business scientific type roles. For example, I've had a vice president of corporate development, somebody that's really dealing with corporate strategy, medical science liaison. So those are all possibilities. One thing that can be more difficult is, I think publications can be one of the easier criteria to meet, because again, if you can show that you've made these publications and they're in peer-reviewed journals, you're most likely going to get that one right off the bat with USCIS. The others can be more subjective, whether you've made original contributions. But especially if we're looking at these higher level positions, then I think it's probably easy to show the critical role. So we can look at that. We can look at high salary is another criteria that we can look at, and that we can even look at equity. So if the salary isn't a lot, but maybe it's a startup and there's a lot of equity, that is another factor that we can consider.
Right. Thanks. That's really comprehensive. Oh, great, Julie. What about J1 visas? Let's briefly touch upon this. So what do companies need to know about J1s before they start hosting J1
Sure.
holders?
So J1s are a completely different animal when it comes to visas. So normally we go to USCIS, they will, or the consulate, and they'll approve the case. In this case, first you have to go through, in order to work as a J1 or be in the US as to study, there's several different categories of J1s. It's really an exchange visitor that goes through the State Department. So the sponsoring entity has to be a State Department designated agency. So some larger companies and universities may have their own J1 programs, but otherwise you'll need to work with an umbrella organization that is set up by the State Department, and then you can be the host organization to allow the person to come be placed at your entity. A research scholar is probably what we see most often. They can stay up for up to 5 years as long as the host entity approves the program. So it can be relatively straightforward in that regard, as long as you're going through the host entity and they approve. But there are some tricky things with J1s. As I said, it is really for exchange, so it's a very temporary visa. It's not one that we would ever suggest using as a bridge to an H1B or a green card for sure. The intent is to return home at the end of the process, and most host organizations will require you to sign a contract that you're not going to sponsor. Some people are subject to what we call 212E. It's a provision in the law that requires them to either return home for 2 years before they can change to an H1B or get a green card. But going back to the O1, sometimes the O1 is a good alternative for people in that situation. You can actually satisfy it in the aggregate, so they can go home for a few months and come back at O1 until they get that satisfied, because you can get it O1 before you have had that you've met that requirement or had it waived.
Right. So a bit of an alphabet soup over here with the non-immigrant visas. But lastly, L1s. Can you talk about L1 transfers and sort of how biotech roles might fit into L1As and Bs?
Sure. So L1s are for multinational companies. So we're really looking for when you want to transfer somebody from one organization to another. So it's called the intercompany transferee visa. There's two types. There's L1A, which is for managers or executives. So, again, your natural science managers might fit in there. Sometimes maybe a project manager or product manager, although sometimes those are great under specialized knowledge, which can also be used for scientists. Specialized knowledge is for those within an organization that have a level of knowledge that is not found normally within the industry, but is also distinct from what's found normally within the company itself. So you're looking at either somebody that has a really niche area or something that is a very advanced area, expertise. So it's, again, not something that you could just hire normally off the street and have a U.S. worker come fill the job, but you may not even be able to have somebody else within the same company. They do need to have been employed abroad for at least 1 year. And when we're talking about entities that would qualify to sponsor somebody, there has to be a legal relationship between the foreign company where the U.S. worker worked and the U.S. petitioning company. And generally, we think of that as a parent or a subsidiary, but we can also use affiliates. So sometimes you want to think, broadly. There's also something called a blanket L, which streamlines the process. So for certain companies that have certain sales, hit certain sales revenue figures and have a certain employee threshold, they may be able to qualify for an L1, which means we can skip USCIS and go right to the consulate for the employee to apply for the visa there. With the blanket, USCIS has already approved and vetted the company entity relationship. So there could be a list of 20, 30, sometimes more entities, depending on how large the company is. And so you might want to look to that. You might not think that there's a legal relationship, but if it's on the blanket, that is, you could pull from any of those companies. So if you have a manufacturing facility, for example, abroad, that you want to place a researcher there or have somebody from there come to the US, that might be a possibility.
Right. Thanks very much for that, Julie. So now we want to turn to industry benchmarking and thinking about ways for biotech companies to stay competitive and keep the talent. I guess in general, the companies that I've worked with, I found that for a successful immigration program, it's really important to have a policy that's clear and saying what the company is going to sponsor, what it's not going to sponsor, setting expectations. And then it's also important to communicate to the not just the employees, but the hiring managers and recruiters, so that everybody's on board and understanding, what the company's expectations and policies are. So we thought it would be helpful to the audience to kind of poll our panelists here. So Melissa, can you talk about premium processing? What are you seeing of your biotech companies? Are they paying for premium processing?
Yeah, and we actually had a question in the Q&A. I think premium processing is probably the biggest request we get outside of normal immigration processing. I would say consistently that the biotech companies I represent, both small and large, do pay premium processing for an H1B transfer. Even though it's not required, you can the individual can start work based on the filing of the application. The employees prefer it because they want that approval before they start work. So we do see it with transfers. With extensions, a little less so. We work with our clients very carefully to initiate sponsorship well ahead of time when it's possible, so we know and we can have the H1B approved by the time their next H1B starts, which isn't required to continue working, but it might be required for travel or for getting a new driver's license. So we want to make sure we're not caught unaware with that. So less employers will pay for that premium processing in those instances. This is one thing where the employees can pay those fees if they choose. And then we'll talk a little bit in our next segment about I-140s, because that varies a little bit on the premium processing fees as well.
Great. Julie, what about dependent fees? Are your companies paying for those?
A lot of companies I have seen pay for those. So basically, if we're filing for an extension, the dependent spouse or sometimes children would need to be included as well. And sometimes the spouse can get an employment authorization card. It's a great benefit. I think the employees really love it when the companies do pay for it. It's not a lot necessarily for the company, but it can add up for the worker. Sometimes what we do see is they'll pay for the extension for the spouse themselves, but if they're eligible for an EAD card, they may not cover that. But I would say the bigger companies certainly do, and it does vary between the smaller companies, but it's seeming to trend more towards covering.
Right. I'm going to turn to you, Melissa, next. What about timing of H1B sponsorship for and entry into the lottery for people who are maybe on L or TN and don't need that immediate sponsorship? What are you seeing? Are companies entering people into the lottery right away?
Yeah, I mean, obviously for the F1s and the ones who will eventually need H1B sponsorship, that is all discussed beforehand, and they do sponsor. If they're going to employ them, they will sponsor for H1B. For the others, traditionally it would be the L1B, the O1, the TNs. Most of my clients will sponsor them for the lottery, but it can be on a case-by-case, and the smaller companies will do case-by-case basis to see if it's absolutely required. But I would say predominantly 75% do. We do also have to check with the employee, of course, because, for example, L1, the employee's spouse is eligible to work in L2 status, but would not be eligible to work in H4. So we want to make sure that the employee wants that H1B sponsorship as well.
Right. Julie, I'm going to turn to you. Since the pandemic, a lot of companies have still kept their remote work policies, or hybrid at least. And now I think we're seeing such an increase in employee requested moves. What should HR and global mobility think about in these location changes?
Yeah, this is a huge important point, especially for those on H1B visas, because they are worksite dependent. So if the person is going to move outside of what we call the metropolitan statistical area, that's going to be considered a material change and require an amendment, which will also require a new LCA with new prevailing wage obligations. So this can be especially an issue for a company if you have somebody living in a low cost of living area, say moving like from Florida to the Bay Area, for example. That could result in a significant pay increase. So it's important to have that, to be aware of those issues beforehand.
Thanks. In this last bullet on our slide, I just want to make sure we're touch upon it. Melissa, what about promotions? I know people in biotech progress really quickly. What are some considerations to think about?
I think the biotech companies promote people faster than any other industry we represent right now. So sometimes it's challenging to keep up with it. We generally look at the USCIS standard for an amendment is a material change in the terms and conditions, very vague. We look at the job duties to see if they're 50% different. Is the person really moving from a predominantly individual contributor to a manager role? Not so much are they moving to a different department within the company, not so much changing from one drug or one product to another, but is the function fundamentally different? And that's when we look at doing the amendment for H1B sponsorship. And then obviously with the green card, it's a different analysis completely about green card sponsorship and when that needs to recommence with a promotion.
Great. Well, I know we are about 5 or 6 minutes beyond our slated time, so I think we'd like to wrap it up. If you have any questions that are remaining, please feel free to reach out to us. And stay tuned for our next installment in our biotech series. As I mentioned before, next time we'll be addressing green card strategies for biotech companies. So please stay tuned for an invite to that webinar. Thank you very much, everybody, for joining today.